We will go on the record in the matter 25 CF22, State of Wisconsin versus Michael Den. The state appears through District Attorney Kevin Schmidt in person. Mr. Den appears in person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of this case. Mr. Den pled guilty to count 5, possession with intent, methamphetamine greater than 10 grams, but less than 50 grams, a class D felony, with having 4 other counts: manufacturing, delivering amphetamine less than 3 grams, possession with intent, methamphetamine greater than 50 grams, maintaining a drug trafficking place, and possession of drug paraphernalia as dismissed and read in. The court ordered a pre-sentence investigation report. The court has reviewed this report. I have notes, but I do not necessarily see that anything jumped out to me as needing to be changed as materially affecting the information to the court. Mr. Schmidt, did you receive and review the pre-sentence investigation report?
I did. I reviewed it. I have no corrections.
All right. Okay. Mr. Keene, did you go over that report with Mr. Den?
Yes, Your Honor. The only thing I would attempt to correct on page 7, it does talk about that he was revoked twice. I would note that later on that page, it talks about those being, 17 days of revocation. So I'd just point out it's a relatively short revocation versus revoke, go to prison. But other than that,
okay.
Nothing that we won't explain when we get to it.
All right, thank you. And Mr. Keene, when I walked into the courtroom, I believe it is Mr. Den's daughter that was sitting up there and she had papers. Is she going to be providing a character statement today?
Your Honor, she provided a letter. She may end up making up her mind if she wishes to speak at the time, because I know she said it's hard for her.
All right, well then she has to make up her mind now, because I usually have the character references, witnesses, as well as the victims make their statement first to allow both counsel the opportunity to provide input or respond if there was something that needed to be addressed.
Okay. Do you want to talk, or do you want to just use your letter?
All right.
Okay.
So you can come up here and have a seat at that black table over there. And you can state your full name if you wish, or I don't care if you want to use initials, that's fine too. If you're going to read your letter, which is totally appropriate and fine, please read it slowly so that the court reporter can take everything down. And I know that this is probably an emotional process for you, seeing your dad this way. So if you are affected by emotion, just take time, take some breath, and then go on, okay?
So state my name first.
Yes.
Jamie Den.
Okay, and it's Jamie, J-A-I-M-E.
J-A-M-I-E.
J-A-M, oh, so just the normal spelling, Jamie.
Yep.
Okay, all right. You may begin.
My name is Jamie Den. I am the daughter of Michael Den. I'm writing to you regarding the sentence of my father. I have a daughter who is 14 and a son who is 9. They haven't had a father figure but my father to look up to. My kids haven't listened to me ever, but they do listen to him. 2 years ago, I had a lot of problems with my son, where he was kicked out of summer school and off the bus. After spending all summer with him, he was a totally different kid that listens in school. I have had the privilege of growing up under my father's guidance and support, and I have witnessed firsthand the positive impact he has had on our family and community. My father has always been a source of strength and inspiration for me, and his dedication to our well-being has shaped me into the person I am today. I understand the seriousness of the situation, and I want to share some insights into my father's character and the positive impact he has had on our family and community. Michael Den has always been there for me or anyone that has ever asked, no matter what. Anyone that has ever asked anything from him, he has always gone out of his way to help with whatever they needed. Like an elderly woman, that husband left and went to another state, didn't have food or running water. My father went out of his way to get her water and bring her to town to make sure she had everything she needed. Even got a vehicle running for her so she had transport to go to town. Last winter, our neighbor would have froze to death because he got sick and couldn't cut wood to put in his wood stove. He ended up calling my father and asking for help. Not only did my father bring him wood, but he split it and stacked it, so the guy didn't have to do anything. Every morning, my father would go there and fill it up for him. I am sure your mind is already made up, but I have lived with my mother my whole life. When I was around my father, all he ever did was work. I hated the fact that he never did anything fun. It was always work. My older brother, for example, all he does is work too. He is getting old and his grandchildren need him. Not only for grandpa, but to be on the sidelines for their sport events, cheering them on. Thank you for taking the time to hear my letter and consider my opinion. I hope that my words will help you in making a fair and just decision.
Thank you, Ms. Den. And so you can understand, I don't make a decision. I need to hear from both of the attorneys and I need to hear from Mr. Den and character references as well as any victims if there are any involved. So I'm just letting you know that ahead of time. All right, argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. I'm going to be arguing for the upper end of what DOC quoted in this one, which is 15 years initial confinement, 5 years extended supervision. I think that this is the correct sentence. I think the main purposes of sentencing the court should be looking at today should be incapacitation, specific deterrence, and protection of the community. I think this is the sentence that does not unduly depreciate the seriousness of the offense and is proportional to the sentences he's gotten in the past for similar behavior in the criminal history. This is a case where a confidential informant did a controlled buy while being surveilled by Deputy Bailey Mogen. He purchased a small amount of methamphetamine from Mr. Den. You can hear them in the recording do this. Police got a search warrant. While staging for it, Mr. Den pulled into the driveway of the same property. Michael Den was arrested in his vehicle. In the vehicle, they found a large amount of methamphetamine. In another vehicle on the property, they found more large amounts of methamphetamine. To give you an idea of the property, it's kind of a property that's got a lot of like junk on it, which is why they search things other than just the building. There are a lot of other places to search. While in custody, Mr. Den was interviewed by police. He said that the source of his drugs is the cities, and more particular, it's a cartel connection. He said he has someone he can contact who would tell him where to go in the cities to buy drugs. He said he buys meth kilograms at a time and splits it with other people to go sell in other places. Kilogram is 1,000 grams. He said this happened every few months. The PSI indicates that Mr. Den has 9 prior convictions. They run the gambit from defying no contact orders to receiving stolen property to drug offenses to fighting with the police, actually. Most relevant to this and what I want the court to pay the most attention to would be on page 9 of the PSI, where Mr. Den described his 2000 Waseca conviction involving him conspiring to import controlled substances. That's the one that sent him to prison for 10 years back in 2000. He said that in that case, he had a connection from California who would take it to the cities and he'd acquire it and break it up with other people to do with what they want. He said he'd do it every 4 months or so. He said, I wasn't dealing, but I didn't really know what they were doing, not my problem. Quite frankly, the offense Mr. Dunn committed here in 2024, and I think it happened in 2025, sorry, 2025 is almost exactly the same as what happened in 2000. The parallels, the similarities are shocking. The foreign connection, the picking it up, the redistributing large amounts of it to other people, and then not my business what they do with it. It's the same. He got 10 years prison for that back in 2000, and he's doing it again here, the exact same thing, using foreign connections to get a drug pipeline and making himself into a fire hose of methamphetamine into the community, 1,000 grams at a time. We caught him here with 100, and the CI bought 1 gram, a mere fraction of what he described to the police. Fact is, Michael Dent is a drug dealer. We know that because he's got the past conviction and the present conviction. And worse than that, what he describes as beyond that, it's really being a drug trafficker, being that middleman connection between a larger wholesaler and smaller distributors in the local community. That's his history. That's what he did here. The 10 years prisons didn't deter him. It didn't stop him. He just moved to Burnett County from Waseca instead. I think a sentence of less than 10 years initial confinement here would unduly depreciate the seriousness of this offense because of that past conviction. If we did the same punishment or less punishment for the same or similar behavior, then what message are we really sending to Mr. Dent, to the community? It defies principles of proportionality. It defies McCleary-Gallion. It has to be more. That's how specific deterrence works. You ratchet up, you don't ratchet down. The repetitiveness of the facts and the offense also demonstrate to me a need for long incarceration for both incapacitation and public protection reasons. If deterrence is not going to work, if 10 years prison didn't work in 2000, then we have reason to believe that it might not work again here, no matter how much. He might come back and do it again. He still has the same connection. He could always open up shop again. He could move to a different county or just stay here and do it the same. That's why any year incarceration this court orders might save the community potentially hundreds or thousands of grams of methamphetamine coming into it. That's a lot of hurt and pain and suffering and potential death that could be stopped from coming here, all while Mr. Dent is in custody, while he's in prison. That's the incapacitation angle. And that's time the community can be protected. I think incapacitation and public protection are really elevated in this case above the other principles we sometimes use in these cases involving controlled substances, just because of the volume and the past history. There's another reason why I think those are elevated here, and that really has to do with the defendant's overall recitation of his history. When you go through in the PSI him describing his past convictions, I think there's cause to be concerned. He's not a great target of rehabilitation and specific deterrence, because when you have an offender who seemingly either can't remember much detail about their past criminal convictions that have resulted in quite a bit of jail or prison, or they recite their past criminal history as though, I had a minor role, someone else is really at fault, where there's deflection, where someone's really to blame, then you have reason to believe that the person's not susceptible to specific deterrence or rehabilitation. Those things only happen. Rehabilitation, specific deterrence only really happen when a person is affected by their own actions through guilt or consciousness or morality or the effect of the sentence itself. The 10-year sentence didn't stop the behavior here. And when you see a person recite, either don't remember or somebody else was the main one at fault, it says they don't really have a lot of insight into their own situation. If there's deflection of blame, then that's someone, we use the broader term accountability or taking responsibility. Those have certain moral implications, but beyond that, if a person doesn't think they did something wrong, if they think it was someone else, or if it affected them so little they can't even remember it, that says that something is happening inside them, that they're not effectuating behavior change either. So there's a bigger reason to be concerned about that, in that, is this going to be another case like the past ones where it's not going to affect behavioral change because someone else is responsible, or it's not going to affect him all that much because whatever reason. And we see a little bit of that even already for this case where Mr. Den clearly tries to say the CI planted half of the drugs and then the other half, which was an enormous amount of drugs, was still just for personal use quantity. We're talking quantities of 40 to, one of them was between 40 and 50 and the other was over 50 is my recollection. If the court has paused to believe that Mr. Den is likely to rehabilitate or to be specifically deterred by the sentence because of these factors, that would be more reason to, when you're balancing the different factors that it has to weigh more in the incapacitation side, more in the public protection side. And I think this is one of those cases. If a person tells you who they are, we should really be listening. And if a person tells us, you know, even after being to prison for 10 years for being involved in large methamphetamine distribution and doing it again, that I don't recall other things, or really I'm being framed by the CI, that should cause the court concern. I think Michael Den has told the court who he is.
You're saying, I mean,
I can't hear him very well. I don't
we have
Can't
a,
hear. We do have hearing devices and we will have Olivia, she'll hook you up. And I can turn the system up a little bit without it screeching.
Thank you.
Testing. Can you hear me?
Yep.
Perfect.
Okay, so he can hear now. So Mr. Schmidt, you may continue.
Sure. I think that Michael Den has told the court who he is, both through his actions and his words. For the second time in this century, he has used foreign connections to secure large amounts of methamphetamine and distributed them into the community. If not directly by himself, by taking the large wholesale amounts and giving them to other people, he knows what they're doing with them. He knows what a person does with hundreds of grams of methamphetamine. He takes no moral responsibility for that. I noticed that when he was talking about his the California connection one, the Waseca one. I don't know what they were doing with that. Yes, he pled guilty to reduced charges, but the facts of what he did are not changed. And his history is massively aggravating. If 10 years prison wasn't enough in 2000, we should be trying 15 now. He is statutorily ineligible for CIP because of his age. I think the court should make him ineligible for the ERP entirely here because of the past 10-year conviction. I think the threat of Mr. Den does not derive from his substance abuse disorder. I think it's his connections and his ability to procure large amounts of methamphetamine, much larger than many people are able to get for himself and others. I think that for the protection of the community, the court has to act here and they have to stop Mr. Den. That should be the purpose of this sentence. First and foremost, to stop Michael Den. Second, to specifically deter him with a larger sentence than the last one he got for really the same behavior. Thank you.
Thank you. Mr. Keen?
yes, Your Honor. I'm just gonna start with the basics. When you look at the gravity of the offense, what I think about is drug offenses tend to differ from a lot of the other ones. We look at the gravity. You know, for example, if you look at someone committing a robbery or an assault, or in worst cases, a murder, homicide, they aren't usually someone who's necessarily suffering from the same crimes, the same effect that we're trying to solve. For example, the reason we have drug laws is to stop people from using drugs on their own and harming themselves. And Mr. Den, when he talked about his past use and his use here, you know, he was a heavy personal user. And in this case, he, sold a amount for the informant, mainly for his own habit. And, the one thing that's sort of mitigating about the offense is that generally people who look for drugs, they find them. It's not, we don't have, it's very rare that someone who, uses and or deals drugs just goes up to random people in the community. Hey, you want some meth? I mean, it's sort of the drug use element. It's sort of a self-selecting community. And I'm not saying that they're in control of their actions, because, almost no one who's in control of themselves would, choose the life of being a meth addict or heroin addict or any other drug, because you see the DACs, we all see what happens when people get hooked. And it's, some people are able to casually use it, but it's a hard line and it's a pretty steep fall. Now, the main area where the DA and I disagree is about the sentencing, and I think that's because we're both looking at rehabilitation. Obviously, Mr. Dent's rehabilitative needs are fairly great because, he's battled a long period of substance addiction. He did have a period in between where he was clean. He did successfully complete a 10 years of probation. It did say revocation, but it was a 17-day revocation. It mentions that in the PSI. So it's not like he was revoked and sentenced for 9 months or 2 years, et cetera. It was, what we would normally think of more of a sanction than anything else. He was discharged from that successfully. His 2018 case, he successfully completed his 2 years of probation. He had some difficulties. It mentioned about appointments. It mentioned, bringing in materials, and Mr. Dent can talk about more when it's his time. But one of the things he's let me know is that, he was in special ed and his reading is probably on the 2nd or 3rd grade level, and that his daughter had to read some of those things for him to do it. So it wasn't like some people where they just choose not to turn things in. He has reading difficulties that make it harder for him to read and write some of those things. The other thing that's sort of unique about drug addiction is that it sort of turns our idea of specific deterrence around. Addicts have, when you're addicted, we think of deterrence as a rational thought process. If you're not functioning, suffering from addiction or some sort of mental delusion, we understand deterrence, that if you do X, you'll get Y. If you do X again, it'll be worse. When you're dealing with addiction, that thought process doesn't really apply. So I don't think the idea that, well, X deterrence didn't work, so this time we need X times 1.5 as specific deterrence really makes sense. Because deterrence applies to when you're thinking straight, and when you're, suffering from an addiction, the last thing you're doing is thinking clear-headedly. Now, the other things like talk about when we're talking about rehabilitation is, some of Mr. Dent's life has changed since in some of his cases. I think when you look at the PSI, it shows that up to around 2012, for the most part, you do have more of a personal history that involves violence. He appears to have aged out of that phase of his life, because I know one of the things when they recommended 8 to 12 years of 8 to 15 initial incarceration and 4 to 5 extended supervision, one of the things they focused on was a prior history of personal violence. But if you look at his conduct since, say 2010, you can see that that conduct is, fade out of his life, especially since the last decade. And that's even factoring that, when he was arrested in 2018, he did plead to attempting to take a weapon from a law enforcement officer. But even if you include that, it's still a lower level than when he was a younger man, and violence seemed to be just, a part of life. Along with the rehabilitation we talk about that they can get, I think when you look at his daughter's letter, the letter from his ex-wife, you see something important is that there's, more of a motive. He has some motivations to pursue rehabilitation. He has reasons not to come back before the court.
I'm just interrupting you right now. I don't have a letter from an ex-wife.
Oh, PO. It should be in the exhibits.
In what exhibits? I don't get exhibits for this until it's received. And then I don't get exhibits until far after it's received in court. So if you filed it as an exhibit, I have zero access to it.
Okay, I'm just trying to,
To talk to CCAP and get that changed back, I would love it.
okay, well, I have the physical copy here of the letter from Paula Olson, if
All
that
right.
works. And
Have you seen it, Mr. Schmidt?
Oh, okay.
Yes, so and I tell all of the attorneys that are in front of me now, we don't get exhibits until after you say, Your Honor, we received this, and I say received. And then once I say received, it still takes 15, 20 some odd minutes for the system to recognize and get back. So I don't usually get it until after the fact.
Okay, well, like to exhibit.
So you should know that for every other county. And if you are going to file things, even if you are going to use them as an exhibit in your hearings, I would file them as just regular old documents and then, or proposed exhibits under a document, not under an exhibit. All right, so let me read this really quick.
Sure. No, in that case, then. I suppose you didn't get his blood sugar levels either.
I got that one.
That
I
one
don't
came
know.
through because you asked for it to be sealed and you attached it to that motion.
Sure.
When things are attached to a motion, they come through.
Okay. I'll make sure.
So that's just food for thought for any other case you have in any other county.
Okay.
All right, I've reviewed the letter. I am now going to give it to the clerk. All right. Now the letter I have reviewed and I've heard Ms. Den's character statement.
Okay, and there I'm going to refer to is just, I have 4 certificates of completion for parenting education. I'll present them to the.
Is he taking parenting education to parent his grandkids?
Yes. I was confused by that. Yes, I was confused by that at first because look at his age, like, well, either you're Anthony Hopkins and we just didn't know it, or we thought that someone was 81. Okay. All right. So as I was saying before bringing the exhibits, I think when you look at someone whose crimes are primarily motivated or, addiction related, I don't think that focusing heavily on the specific deterrence is necessarily useful. Now I'll deal with the proportionality. Again, we're not dealing with someone who's in a rational state of mind, not insane or anything, but just, addiction, that whole rational thought isn't there. So I don't know that proportionality necessarily makes sense. Okay. But Mr. Den, according to the PSI, did succeed on probation, even with some hiccups. And that was during COVID probation where most of it was virtual. And I tend to have the same skepticism of virtual probation as this court tends to have about signature bonds. That, unless you can see the probationer on a fairly regular basis and see if, what services they may need, or if they're lapsing, a Zoom has its limits. But despite that, he still made it through, and he did end up having to go in once a month because with his reading difficulties to go over things with his agent. So his agent did, within the ability of limitations of COVID, provide supervision. But those things show that, when he's monitored, and the PSI said the same thing, that when he's monitored, he tends to do better. And that, oh yeah, there it is, page 27, where it says he continues to repeat the same behaviors when there's nothing to hold him accountable. And that's on page 27. I would suggest that, there's some built-in accountability with time in jail, and I'm
Thing on page 27, because my 27 has recommended where it has sources of information.
okay.
You're talking about the PSI, correct?
Yes,
I do recall what you were
Okay, then-
stating.
yeah, okay, then strike the page part
Under
of
a
it.
watchful eye, he behaves better.
Yes. But along with the coercive elements of probation to keep him on, is to try and keep him on the straight and narrow, his daughter and his ex-wife have talked about, some of the motivations to succeed on probation is that, he does have, grandchildren who need him. He does have his house that if he's sentenced for a lengthy time, will, when he gets out, he'll pretty much be a homeless man. He did show that he has successfully completed before. And it does show that, for a man who was, in younger days more violent, they both mentioned examples of where he's trying to help members of the community as well. And I'm not saying to minimize the drugs that were shared, because, we recognize that drugs, have been a scourge to the community, whether people take them or, hunt them down or not. But he does have more motivation than most of my clients, because he has, or it was like most of my clients are right before me aren't this old. They don't tend to have the family members who rely on them, and they don't have the assistance available. And they also don't have the track record that when they are monitored, they can actually complete probation. And then when you look at his needs, so when he was arrested, his the Burnett County Jail had his blood sugar level at one of the ones, which is like a day or two after his arrest, was around 600 and something. That's dire medical attention, and it took them, 3 treatments, of heavy doses to get it to a level where it isn't, you pretty much need to go to the hospital. When he was, at the time he was arrested, when he was taking all these substances, he had a diabetes problem that was so severe that he lost multiple toes. And diabetes tends to aggravate or bring on depression. And he'll talk about more in
I was
his.
gonna say, I'm lost in your argument.
Okay.
Honestly, way lost. I get the fact that he has diabetes, and I get the fact that his blood sugar level was skyrocketed to over 600 when he was arrested. And he lost toes because of this. But when he's arrested, and why is that a big deal? Are you indicating or informing the court that you believe that the jail did something wrong?
No, you are. What I'm doing is pointing out that his mental state at the time, in terms of, not really having much of anything to live for, and he'll talk about that more. And that now that he's had time in custody, his diabetes has been treated, and he's had time to, you know, because of the diabetes treatment, deal with some of that's lowered some of the depression issues. That's something that can be considered when looking at his future conduct versus his conduct when he was arrested. So I'm not saying, no, Burnett County Jail, because they treat him, may have saved his life.
I think they did say.
Right. Now, the reason I say may is because his blood sugar was obviously high when he was arrested, still high. And, I don't know how long he'd have, survived before then, if it would have come down, if he hadn't been arrested that day, if he'd have taken whatever. So no, I wasn't using that to say that the jail was derelict in their treatment of him, just pointing out that, when he was arrested, he was in very poor health, and that poor health affected some of his choices that led him to sit here today.
So that's what you're saying?
Yes.
Now that he's in good health, he's going to make better choices.
He's more likely to make better choices. I don't guarantee anything, and I think anyone who does guarantee the court anything is,
Yeah, it's
No.
always an error, maybe. We don't have a crystal ball.
right, but it makes it more likely. And then he's talked about the other things that, he said he's done to rehabilitate himself or make him more likely to succeed and not go down the same road if he has a lower sentence than that recommended by the state or the PSI. And I'll leave that in his own words. But I did want to point out that, he's a man who is at least now looking forward to the future. He's saying, I've been, in essence, trying to be like not a father to my grandchildren, but I've had a parental role. So he took some of that time in jail to take some classes to help him do a better job of that. And he's, taking care of his health better than it was previously. And yes, the jail's obviously directed that because they've monitored him. And, if he's released when he's released at some point, whether it's now or several years from now, okay, not now, I'm not gonna ask for a release today, obviously. But when he is eventually released, it's up to him to make sure that he follows up and doesn't get himself back to that physical condition that affects his mental health.
And you're bringing me back to other questions, though. He knew of this prior to even getting arrested. He knew he had health conditions. He did know that they were affecting his life and his ability to think properly. And now that they're under control, he's going to make better choices, but he could have controlled that before, went to a doctor before and got it under control before.
Yes, Your Honor. That's sort of the $1,000 question in any criminal case is, why you didn't do it yesterday.
Because he wasn't facing prison yesterday.
Well, and
Figuratively speaking,
Right.
yesterday, not literally yesterday.
right, I understand. But I mean, just in terms of, sometimes that access to service that's enforced, does help. I mean, but, all right. Right, so what I do is to point out that he does have some motivations, and the court doesn't need to do a 8 to 15-year prison sentence to ensure accountability and to ensure that Mr. Den has something to keep a watch over. This court has tended to use imposed in state sentences more than some of the other ones in which I practice. And, that I'm not saying that's good or bad. In this case, it'd
Court
be
does
good.
a lot of things different than other courts in our district.
Right. And like I said, I wasn't saying that as a bad thing. And there are cases, including this one, where I think that specific accountability or where upfront what you're getting is probably useful. And that's one of the things I'm arguing for.
You never know upfront what you're getting. A judge has discretion all the time, no matter what, even if they're recommending probation. all the time. You
What,
don't know what you're getting.
yeah, what I meant by upfront is if he's on probation or at some point, well, if he's on probation and there's an imposed stay, that's different than cases where you go back to the court and then the judge decides your sentence years later. That's what I was talking about, knowing upfront. I was,
All right.
right, because
okay.
I recognize, I've talked to Mr. Den, he's aware, we're all aware that Wisconsin doesn't do the sentencing guidelines like a lot of other states where you know exactly, or you almost know what's going to be in most cases. So I was talking,
In sentencing, you don't even have the other than early release programming. There's no
Right.
good time in Wisconsin for prison.
right, he's aware that too, well, so that's what I was referring to is that the, where you know what you're getting, as I was talking about, that if you were on probation and revoked, that he would at least
Have a better idea.
have an idea that's not come back to court and hope I get lucky. It's just, you can see the size of the noose hanging over your head is probably a way to phrase it. Okay. Well, not noose, I was thinking about guillotine, but okay. All right, so,
Or you have the carrot and you do better.
well, right. I mean, carrot stick, I mean, but fear is sometimes a better, you know, you can call, whether it's fear or motivation, people are motivated by different things. And the carrot is that you're not going right away, as I always look at it.
Here it is. You have the ability to never go away.
Well, yeah. But, okay, but that's more of a half full, half empty glass philosophy thing, probably. All right. And the other thing I note with regards to his ability to function under supervision, even in the community, is that in the 2018 case, he did a year of home monitoring and successfully completed that along with the probation afterwards. And the other issue when we look at it is when we get to protection of the community, there's two ways to look at it. The DA suggested one that if we throw him in for 15 years, we're protecting other people from Mr. Den.
His argument was actually 10 in.
I said
Oh,
15.
you said
and 5 out.
15? Oh.
No, he said 15.5. He was arguing
oh,
for the max.
15.5. Okay, thanks. I wrote it down wrong.
Okay,
15.5.
yeah. But the other way to protect the community is through supervision of Mr. Den. And, you know, having that deterrence hanging over his head, knowing that, you know, even if you're given a chance by the court to go back to, you know, helping your grandchildren and other things, you have that hanging over your head that you could set this amount of time. And along with the actions he's taken since being in custody, specifically that he'll talk about more, he's also, you know, as the courts where he also had to take care of his physical property. It had a forfeiture order. And as far as Mr. Den, I know he's, you know, through his people, he's taking care of his property. So that's something, a sign where he's showing he's trying to take care of his future and have one. And when you look at whether the people's incentives and motivations, whether they think they have hope is also a factor in whether or not they're likely to be successful versus people who feel like everything's lost and there isn't hope. And like I said, when it comes to protection of community, I think when you look at drug crimes where the person's also, you know, is an addict, I think that one way you show that is you show that people can recover from it. It isn't just death or prison. You show that, you know, someone can, under heavy supervision, show that they can, you know, choose to recover and take the steps to recover on a daily basis to try and become a part of the community again. And I think the other thing when you think about protection of community is that, you know, drug addiction and taking drugs isn't a random thing. It's not like you're walking downtown Grantsburg and bam, all of a sudden you have meth in your hands. It's, you know, a lot of times it's people making choices. And sometimes the difference between someone like my client, Mr. Den, and the people who tend to be informants is that the informants, got caught with a lesser amount and then chose to make a deal and collect someone else, but it's a lot of very similar behavior. So I said, I want Mr. Den to talk about his, how he's trying to do the rehabilitation, what he's trying to do. But I think one way that the sentence could work would be for 10 years of probation. The only reason I don't say the max of 15 is because I know that empirically there's absolutely no evidence that 15 years of probation means anything. And 10 probably doesn't, but frankly, the gravity of the offense means that 5 years probably would not be appropriate. And I would suggest that a 1 year initial as a condition of that probation, 1 year of confinement in the Burnett County Jail. If he's able to work out home confinement for the rest of it, since he's been in here since January, that'd be so he can take care of his house. That would be up to jail and obviously court, and then an imposed and stayed sentence of 10 in and 5 out. Because then he sees it, he understands that with his age, if he goes in, by the time he would get to see his, depending on when he got revoked, of course, but if he got revoked like halfway through it, the odds are pretty good that, the only way he'd ever see his grandkids for the rest of his life is through whatever visitation the Wisconsin state prison system would allow. But like I said, drug crimes a lot of drug crime, and we know that Mr. Den wasn't, like the caricature of most people who have drugs and provide, sell them to other people. Because the caricature is that it's like, my favorite movie, Scarface, where you get the castle or the big mansion and all the women and the cars and all that stuff. But Mr. Den's house wasn't much. The video shows that, lots of it weren't great repair. He had one bedroom that was sort of habitable, and that was about it. So I don't think we have the same issue in drug crimes with the seriousness of the offense. With the protection that we have in some of the others, because usually you can protect the public from people who are, usually users on a heavy basis. One way you protect the community is by supervision to keep them from using. Because if he doesn't use, the odds are pretty good he wouldn't go anywhere to buy. It's not like a robbery ring or something like that. He's suffering from the same things that we're trying to prevent the court from, the same problems we're trying to solve through legislation and criminalization. Mr. Den does have, a lot of things to live for. He has specific motivations to, if he's sentenced to a probation sentence with a year as a condition of that probation, he does have a lot of things to hold over his head. He does have family, a daughter, grandchildren, even an ex-wife who was willing to write a letter. And if you'd put on my bingo card that I'd be submitting letters from an ex-wife for somebody, that probably wouldn't be high on the bingo list, because usually you don't think of ex-spouses as great personal character references. But he does have those things. He also does show that he aged out of a lot of the violent conduct that the probation agent put in the PSI said was more likely to make him engage in criminal behavior in the future. And Mr. Den can, you can try protecting the community either by just purely locking them up, which is certainly an option, or it's a very expensive option, or the court can lock him up for, you know, what we think of as that minimum amount of time needed to, you know, establish some sort of deterrent, any sort of deterrence, and with an imposed and state sentence of 10 and 5, or not, I didn't say 15 and 5 in my recommendations, just because of his age. 15 and 5 is pretty much a death sentence for most likely with his health. 10 and 5 maybe as well, but you know, it's a couple of different ways you can do it. And I think that when you look at drug crimes where the person that's being sentenced is a serious user, I think you have to look at that different than when you look at someone whose serious crimes are assaultive, when they're theft related, or some of those other ones. So the defense, we're asking, like I said, we're asking for an imposed and stayed 10 in, 5 out with 1 year of confinement in the Burnett County Jail as a condition of that probation. And the terms listed by the agent and the ones that you normally impose anyway on drug cases would probably, would reasonably work. Thank you, Aaron.
So if I'm hearing your argument correctly, you're indicating that since 2010, 2013, he's aged out of the violent conduct, so it should be viewed as less serious.
I'm saying that factor that the agent put down should be less viewed. And that's even acknowledging that in 2018, one of the charges to which he pled was, you know, the felony of trying to take a weapon from an officer. That's not, I think when you're facing an arrest, you know, that's definitely not when you're in a rational mind for a person. And I think that's more of an aberration to how he's lived than the record shows, where the other ones where it's like, well, I had a gun with someone who stole my stuff or had issues with this person or that person. So that part I think is less of a criminogenic factor or reason than what the agent put in the report. Oh yeah, sorry. And if the court disagrees and thinks prison is necessary, I would suggest that, you know, the sentencing would recommend that an ERP eligibility would make more sense because of, you know, a lot of it's use related than not having him eligible as a substance abuse. Thank you.
Thank you. All right, Mr. Den, I'm now going to turn to you. This is your opportunity to provide any statement you wish to the court. You don't have to, but it's your only time to give me anything that you think would impact or come into play with my sentencing decision. I see you have papers in front of you. Are you going to read something?
Yes.
If you're going to read something, the same thing that I said to Miss Den, please read it slowly so that my court reporter can take everything down. And if it does get emotional, you can stop and take a breath before you begin again.
I would like, whoa, that's really loud. I would like to say that other than the 2018, my drug conviction in 2000 was 25 years old. My assault and break and restraining order was in 99. And it was all over the same course of actions through a divorce and stuff. And that was over 25 years ago. I do take responsibility for having the drugs and selling to supply my habit. I don't even own a vehicle that runs at the moment. So I was making fistful of money run around. I pretty much lost the will to live. I lost my godchild. She was 8 years old. And someone ran through a four-way stop and ran her over and killed her instantly. I lost my best friend in 2024 on day before Christmas. And I lost the will to live. I had diabetes, which I've had 2 friends die from it in the same condition. The reports mental health, you can't measure one way or another. With my diabetes, you could measure it. Granted, I wasn't taking care of it. I didn't want to live no more.
What would that have done
My
to your
father
grandkids?
hung himself, and I always thought that was a cowardly way to go. If my father did not commit suicide, most likely I would. I lost the will to live. I can tell you probably 10 people in the last year and a half that's been to my place.
I don't think he heard your question, Your Honor, because he'd had to take office.
That's fine. He
Okay.
doesn't need to answer it.
Well, I'll give it a chance.
What was
What she asked was, what do you think not having your will to live to do, not having a will to live would have done to your grandkids if you died?
I didn't take that into consideration. I was being selfish on my own. I shut everybody out. I didn't go to Christmas in 24. I didn't go to Christmas in 25. And that whole year, I never went anywhere. And very little did I have to do with my family or anybody. If I wouldn't have got arrested when I did, I'd probably be dead by now. So no matter what happens, I'm still alive and able to talk to my grandchildren. I would like to read, I got one for the Burnett County staff. At Christmas of 2024, I was without love and the will to live anymore. I was sick. I lost my best friend on 12/24 of 23. I no longer wanted to live. I lost 2 toes. Next was my foot. I could not go out in the heat or the sun. My diabetes was out of control. I did not care. I did not want to rely on anyone to help me. January 27th of 2005, all that changed. I came to jail with diabetes. When they tested me, it was 600. And that was 4 days after I was arrested. So it was more like 800 and plus. Jail staff was scared for me and got me help, and the COs of the jail helped me every day. They the jail helped me every day. They took me to the hospital 4 times since I've been in, and every day they checked my blood sugar 4 times a day. I no longer feel that I'm going to die. Coming to jail saved me. Thank you, Burnett County jail staff, and the help you all have done for me and saving my life. I am asking the courts to please understand and to prove to all the people that have helped me to change my life. The staff and the NA and the AA Bible study, parenting class showed me the will of God and the power to live. And, you know, I went to the hospital, doctors, okay? They said, if you don't take care of your foot, we're gonna cut your foot off. I already lost 2 toes. I wasn't going to let them cut my foot off. couldn't do the stuff I had to do to live, and I didn't have the will to ask for help. And I'm thankful that my bail was as high as it was, so that I wasn't able to bail out, that I could focus on my problem and my addiction. And now that I'm thinking clearly, I just hope and pray that I have the chance to prove this, rather than going, if I go to prison for 5 years and get out, I got nothing. And at my age, to go try to ability to rebuild is pretty tough. I finally got Social Security 6 months prior to this. And so I have a steady income coming of $800 a month. I was on probation and home monitoring for a year with no problems at all. The only problems I had was not doing the homework assignments. And that was because I couldn't read them and didn't understand what I read. I have a 4th grade level reading.
Who helped you write your letters today?
I wrote them. And it's the only ones I've ever wrote in my life.
Well, it sounded really good. It sounded very together.
You know, time to time, I've had God in my life, and this time God's in my life forever. I do believe that being here has changed my way of looking at life and what really is worth life. I feel I can be a positive to the community, to help out younger kids in the same situation that I was 26 years ago. And you know, you said, well, he could have got help. I could have, but I didn't want to ask, and I didn't want to live. And depression runs in my family, with my dad hanging himself as proof of that. It's not something that I just came up with and making this up. I have 2 toes that are amputated, and my foot, which I've been incarcerated for 7 months, and we take care of it continuously, and it's still not healed, which on the outside would have never taken care of it, because I had no will to live. When you lose that will to live, it's just like you can't even stand yourself. You can't stand yourself to look in the mirror. You can't stand talking to people, especially loved ones, because you're not giving them the full ability of love. And I myself never reached out and asked for help. I didn't ask Burnett County to help me. They volunteered. The COs didn't have to do everything they have done. I mean, every day it's, 4 times a day, they have to come and see me one-on-one. And there is better life than what I was living. And who knows how much more. I'm 64 years old. I don't know how much more time I have. I know that no matter what happens, I will make it through it. it would be hard to get out in 5 years or 10 years and try to find a place to live and stuff. Cause I will be cut off Social Security, so I would have to sell my property anyway, and so that would be a loss. I don't want to ramble on. I just want you to know that I do have the will to live, and whatever happens, happens. I understand you have your job to do. And if you could see and give me the chance of a state imposed sentence or what time over my head, if I screw up, you're gonna know right away. I mean, I quit smoking in 2000, haven't smoked since. I quit using meth for a long time, and then I started using again. And I didn't have no income, so I made so I could use the meth to get up, to fill the wood burner, or just to get out of bed, or to just get moved. And when you'll never to explain, you know, when you said, why didn't you just go get help? It's not that easy.
I wasn't saying mental help. I was saying physical help from a doctor who can help you with your blood sugar.
That's what I'm talking about. It's hard to go there and do, and I don't understand. I understand, like, as soon as I leave, I go, you know, I don't even know what drugs I was on and stuff. And, you know, I had COVID, I was in the hospital for 18 days, you know.
I'm really easygoing and letting the defendants go, this is your time, but I'm hearing the same things multiple times, over and over, just in slightly different words.
Okay.
And we need to wrap this up because I scheduled this for 2 hours and we only have 45 minutes left.
All right.
So I just want to make sure that you have everything, and I still see letters in front of you. If you've said everything that you want me to know before I sentence.
Yeah, I think if I can ask him one question that deals with what he's talked about. Okay, you said that you were talking about rediscovering God since you've been in jail. And these are things you wrote down. So what are the things that you've done as part of that journey in your life?
I've attended all the AA meetings that are possible, and the NA meetings, and Bible study and church. And I've met some stand-up people that gone through the same thing and that have changed their life. And, you know, nobody at 64, you don't know how much longer you have. I don't think I'm going to live to be 80, but it would be nice to know, hey, he's going to live till 80. And with that, I'll just leave it up to the courts. I appreciate everything that has happened, that I do know there's a better, sober life out there when I do get there. If I do screw up, then, you know, I'm just sitting here bullshitting you, and that's one thing I don't want.
Yeah, you really shouldn't use that language either.
No.
Okay. All right. So I've heard a lot here. I've heard a lot from you, Mr. Den. I've heard a lot from your attorney, and I've heard from the state in their argument. And I also have read this pre-sentence investigation report. I read it, I highlight it, I make notes, I do all of the things that I need to do. I've read it more than once. So I've heard a lot from both you and your attorney that you are now a changed person. You now have this will to live. And now because you see that, you're more likely to do better, more likely to make better choices. And I do believe that that can happen with individuals. I see it a lot. I see not a lot, not as much as I'd like to see, but I do see people sitting in that chair that completely turn their life around and then they start to do good things. But it was a slip of the tongue when I said a lot. I don't see it a lot. I see a lot of people sitting in that chair saying, I now understand I needed jail to,
Could you hold, put it back on?
yes.
Thank you.
All right. Can you hear me now?
Yes.
Okay. So I see people sitting in that chair who say pretty much along the same lines of the things that you told me today. I've had time to reflect in jail. I've realized the error of my ways. I'm going to do better. I have changed. I now have a better outlook for life, or I've now had the will to live. I've heard that from, I can't even count how many people. And I've also heard from a lot of people sitting in that chair, I have found Jesus. And you said, I have had God in my life from time to time. This time, God is in my life forever. You've been in custody for 7 months. You've had access to all of our great resources in Burnett County, which include a few pastors and having those services. I commend you for finding God. I commend you for having that higher power that you look up to, that you are looking to help keep you on that path. I do. And I truly hope that this is something that has now been instilled in you so deeply, it's not going to change. But again, I have people sitting in that chair who say those things, who once they're released from custody, where'd Jesus go? I can't find him. Oh, I lost him. Over and over again. Religion and belief in God and Jesus doesn't just happen in jail. You can't just be incarcerated and say, I found God. I'm going to change. I'm changing my ways. It takes a whole lot more to do that. You have to change your habits, change your associates, and completely change yourself to significantly improve your life. You can't just modify some habits, and you can't just say, I found God to have these changes. Change your habits, change your associates, and change yourself. And it's not an easy process. It's not something that people can easily do. Or we'd have so many good people, we would never have divorces. We would always have, you know, everybody doing the greatest things because they see an error in their ways. They find God and it's changed. It takes a lot of work to do that. I have you sitting in front of me today for a very serious crime.
Yes.
And I understand that in this case, with these facts, there were not any underlying violent or assaultive behaviors. It was an undercover buy with a confidential informant. It shouldn't get violent or assaultive. And then what led from that is a search on your property that yielded approximately 100 grams of methamphetamine. That's a lot of methamphetamine. That's a lot of methamphetamine. It's not just a little. That is way dealing, way selling, way being an involved drug dealer. And I do understand that you said that I've heard it, but again, I hear this a lot. I was only selling to support my habit. That's all I was doing. And all I had, I didn't have a lot. I had a fistful of cash. I don't have a good car. I don't have a good property. So I wasn't making a lot. I was just supporting my habit. Well, you took a lot of risk. You had a lot hanging over your head to simply support your habit. When you could have made better changes, you could have done things differently, but you weren't facing a lifetime of prison. You weren't incarcerated for 7 months. Since you've been in Burnett County, I don't believe you've been incarcerated that long, except for the monitor. But then again, when you're on electronic monitor for a sentence, unless there's an attaching probation, you're not really eyes on being monitored. Not making sure that you're not using methamphetamine. It's not making sure that you're not engaging in criminal activity. We don't know what you're doing. There's not a camera in there 24/7. And I'm going to tell you, there's been quite a few people on monitor that continue to commit crimes. They know how to do it and they think they're going to get away with it. Some do, but most get caught. So some actually do get away with it because we don't have the eyes on supervision. So we're dealing with a very serious crime. And that would be the selling and distributing of this poison drug, methamphetamine. And you've had the benefit in this deal. I am going to say this was a sweet deal. You did plead guilty to one serious crime of possession with intent, greater than 10 grams, but less than 50. But you also had on your plate, and you could have been convicted of possession with intent greater than 50 grams. There was almost 100 grams or a little bit more than 100 grams. That's a lot. And there's a lot of a difference in the amount of prison time that could have been hanging over your head. So that's why I say this is a sweet deal. Because if you went to trial and if you were found guilty on all of those counts, all 5 of those counts, you faced 81 years of incarceration, 81 years, with approximately 49 of those as initial confinement. 49 of those you could have sat in prison. That's essentially your life. And it was dropped down to 25 or 20 or 25. It was 25. So a possible 15 years of initial confinement as the max, 10 years of extended supervision as the supervision piece, which could later be served in prison. But it dropped from 81 years over your head to 25. That is a sweet deal. So I look at the seriousness of the offense. I have to look at your character as well, and also that need to protect the public. And so bringing in all of those, I have to look here with having very different recommendations. I have one from the state, 15 in, 5 out. I have one from Department of Corrections, 8 to 15 in, 4 to 5 out. And I have a recommendation from your counsel of 10 years of probation, 1 year of conditional jail with an imposed and stayed sentence of 10 years in, 5 years out. They're all different. But we know here, or we should know, I know there was an argument for your attorney for probation, but here for the sentencing, with 100 grams of methamphetamine, 100 grams, even though you pled to 10 or 50, no more than 50, that's what you pled to. But in the facts, in the evidence, there was approximately 100 grams of methamphetamine. It's not a given prison sentence, but prison must be contemplated So the dispute here is what should the court do with sentencing? And your attorney would like me to look at probation. Consider probation first. A court considers probation first unless confinement is necessary to protect the public from further criminal activity from you, okay? Or you, the defendant, you need some kind of correctional treatment. You haven't taken it upon yourself to get the treatment yourself while you were in the public. And so you've been forced to get it. You will get it if you're in an institution, a correctional facility. You said today, exactly, jail saved your life. But for the fact I was incarcerated, I wouldn't have got my health under control. I wouldn't have regained my desire to live, all of those things. I also have to look at probation. Unless probation would unduly depreciate the seriousness of the offense. Unduly depreciate the seriousness of the offense. So you have to look at this offense and you have to determine how serious is this? Are we dealing with 1 to 3 grams of methamphetamine or residue in a pipe? Or are we dealing with 100 grams of methamphetamine? This is serious. This is a very serious crime. And at the plea, the court went over that dismissed and read-ins can be used against you for sentencing. You can't be sentenced above the maximum penalty. But all of those dismissed and read-in counts come into play. And the court looks at those. I understand and I hear you and I believe that you used substances. You used methamphetamine. I need to determine, are you simply a user or are you a criminal? That means a user who sells, a user who engages in other criminal activity, burglary, anything else. What is it? You claim that you're simply a user, but for the circumstances, you needed to have more money in order to support your habit. You weren't making enough on Social Security. But then again, we have 100 grams of methamphetamine. This one time in life where law enforcement went and they went kaboom and they picked one point in time and they found 100 grams. Statistics would show and theories would say, this isn't the only time you've had 100 grams of methamphetamine. This is the time you got caught. And you got caught because of a confidential informant, and that's sale. And if I'm reading the PSI correctly, you're not accepting the responsibility. I've heard a little bit of accepting responsibility today from your attorney and yourself. But in the PSI, when all of this information was brought in, I didn't hear any acceptance of responsibility, any accountability. It was passing the blame, passing the buck to somebody else. Because you stated that the reason you had all of that methamphetamine is because you allowed someone to stay at your property, and when you kicked that person out, the methamphetamine was just left there. So you're trying to have the court believe that whoever was staying at your house had the methamphetamine and you kicked him out and oops, the meth stayed, oops, you got caught. And if I'm recalling correctly, the alleged CI is the alleged person you kicked out. Why would the CI go and buy methamphetamine from you if it was his methamphetamine? That makes sense. It just doesn't make sense. You did claim ownership of 56 grams of methamphetamine located in one of the vehicles. but you claimed it was only for personal use. You never sold methamphetamine to anyone. That's what you said. I read it. I read it
Okay.
multiple times.
I'm sorry, I.
You lied.
Okay,
So you don't get to talk now. I do.
sorry.
But I hear today the complete opposite of what's stated in here and the alleged facts in the criminal complaint. You're passing the blame to somebody else. Wasn't my meth, but I was going to sell that meth back to the person who left it. That makes sense. It just doesn't. And claiming ownership of over 50 grams of methamphetamine for personal use also doesn't make sense. A big part of the court in sentencing is looking for remorse, looking for real positive change, looking for someone who is going to be open and honest, albeit not tell every single fact, but about the crimes. But here you did not accept the responsibility. You just had excuse upon excuse and reasons for damaging our community, for being a part of a destruction of our community. This is the community where your daughter lives, where your grandkids live, where perhaps you have friends here and they live. This is the community where your central family friend connection, they reside. And you're a part of destroying that.
Yes.
So the court has to determine, does this sentence rise to a maximum possible penalty? It might.
Yes.
You're saying yes, it does?
I was out of control. I was not.
I would just, okay, because you're saying that I should sentence you to the maximum penalty.
Yeah, I think when he said yes, he was just talking about yes, and he understood that that was your thought process versus saying, you know, because I can tell you, I've talked with
Maybe
these.
he should zip it.
Yeah,
My time to talk. I went on and I heard for over an hour from your attorney's argument and your argument. I've heard it from both of you, but now it's my time to talk. This could be maximum possible penalty, or it could be looked at as something a little bit lesser. What the court has to look at here, and I'm focusing on as well, is your character and your rehabilitative prospects and the need to protect the public. You do have a criminal history, a lengthy criminal history, one that involves a crime very similar to this, albeit from 2010, but very similar fact pattern, very similar connections. You have connections with the cartel, at least one cartel, maybe more. I'm not sure. To me, that's telling me that this is more serious though, and it could involve violence because I've not heard of the cartel giving out flowers and candy when they're not getting what they think they deserve. Violence, guns, deaths, a lot of assaults, substantial batteries, a lot of those things happen around cartel activity. Again, not a circus, not a party. So just because this didn't involve violence, again, because you were taken out of that brief little part of the timeline, doesn't mean that there hasn't been or couldn't be violence associated with your actions and your crime. So in needing to protect the public, I have to look at if there are victims. We don't really have real victims here, not victims of substance, but we have the community as a whole, the people that live here, the people who have been impacted by your criminal conduct, including the people you have sold methamphetamine to and their families, because they have all suffered. They have all been harmed. They have all been affected in some tangential way. And that includes your grandkids. They've been victims here too. Your daughter, she loves you. I have seen her in here multiple times supporting you. I'm going to guess she doesn't love what you've done or love some of the things you've done, but she unconditionally loves you. But she has been a victim too. So as your son, who's now sitting in prison in Minnesota, he is a victim too. And you've been doing this since you were young, early 20s, early 30s. Pretty much Ms. Den's whole life. I have not seen her in here, and I praise her for that. She is leading a good life, and she is raising her kids to the best of her ability. She has a strong will. So she has not followed your path, which is good. So I have to look at other things in protecting the public, such as what Mr. Schmidt has said, specific deterrence to specifically deter you from engaging in this type of activity and crime, general deterrence to say, hey, public, hey, people who want to do this, I think you should think about this again. Take a second thought, because I don't know if you want to have this potential consequence, this potential crime. In sentencing an individual, I am told to give confinement an amount that is consistent with those things, protecting the public, the gravity of the offense, and your rehabilitative needs. Those are what I need to focus on. And here, it's hard not to see the harm and the seriousness, and it's hard not to see the level of criminal thinking and criminal involvement when this was an undercover sale. So how many times did you actually participate and engage in this destruction, selling of this drug? Most likely, multiple times throughout your time, multiple times, at least around 2018. And other than that, I can't be for certain. I don't have evidence of that. But a lot of times, because you got to know, crime happens everywhere. We just don't see it. And people just don't get caught. It shows a lot of criminal thinking. And I commend you for having a heart. I see that you do have a good heart. And I've seen that, and I've seen how you've acted towards your son. Is his name Josh? Josh. And you've acted towards Ms. Den, and how I hear how you are with your grandchildren. I see that. Good people can have bad qualities and make bad choices in their behavior. You have helped, as your daughter said, an elderly woman to make sure she has all of her things, even though you don't have money. Did she have food? Does she have a ride? Does she have a place to live? All of those things. I do see the good qualities that you have. But so far, the good qualities have not outweighed the seriousness of the criminal offense. Because again, I have to say, our county, our community is being destroyed. Families are being destroyed. And here you are not just a user, you are an addict. You are part of this and being a devil of the destruction. I see changes from the time you were arrested, and I hope those changes and that rehabilitative steps and your cognitive thinking, I hope that continues to change and to solidify, and that you want to be a contributing member of society and the community. You want to be the grandfather and the father that you weren't at all times. You want to be there and be present. I see that. Hopefully that'll stick and stay. And I did hear your medical issues, and I do take that into account. And I did hear about your now having a will to live where before you didn't, so it just didn't matter. I do take those things into account. But they're not necessarily reasons not to send you to prison. Those are reasons to show, look at, I am changing. Things can happen. I now see a brighter future. So in sentencing, again, the seriousness of the crime and the need to protect the public outweighs the character, well, outweighs the rehabilitative prospects. Because this is very serious. So with regards to count 5, possession with intent, amphetamine, methamphetamine, greater than 10 grams, but less than 50. I am sentencing you to 12.5 years of initial confinement and 8 years of extended supervision. And that is imposed immediately. This is too serious and too much of a need to protect the public that can't be overlooked. And a sentence less than this would unduly depreciate the seriousness of the offense. I am not making you eligible for early release programming. If you were a straight user, definitely. This took a lot of intent, a lot of planning, a lot of dealing, a lot of figuring out who your contact should be in the cartel. That it's not simply because you're a user, you are a criminal. And the fact that you used just means that you made that choice. Made the choice. A bad choice, but you made that choice. And you made the choice to use methamphetamine with knowing the effects of methamphetamine and how addictive it is. You made an informed decision. You also made an informed decision when you decided to sell and engage in delivery of methamphetamine. As conditions, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, criminal thinking or thinking for a change or breaking barriers, one of those programs. You must follow the rules of supervision, regular drug testing, no contact with anyone who is on felony drug-related probation or extended supervision without approval of your agent. Absolute sobriety, no alcohol. I'm ordering you to provide your DNA. The jail will make sure that they take that. I don't believe this is one where it can be expunged. $518 in fines and fees as it relates to the felony. Jail credit,
196 days, Your Honor.
196 days of jail credit, no use or possession of an illegal drug, or no use or possession of a firearm for life, no voting in any election until your civil rights are restored. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you, but you will also be subject to a warrant and a potential of 6 months more of incarceration. Again, if I did anything lesser, it would unduly depreciate the seriousness of the crime as well as the need to protect the public. Mr. Schmidt, anything that I'm missing?
Not for me.
Mr. Keen?
No, Your Honor.
All right, then we are adjourned. Thank you.
12 and a half. Right, no earpiece.